I am reporter number 7, Johanny Maripi Sinyosa, and my topic is all about legal and ethical considerations under Chapter 2, Historical, Cultural, and Legal or Ethical Considerations. So the topic outline, legal and ethical considerations, code of professional ethics, standard of care, the concerns of the public, the Common Core State Standards, World War I and II, legislation, and litigation. Intended learning outcomes. To determine the legal and ethical considerations. To identify the concerns of the public in the assessment enterprise. To define legislation and litigation. Laws are rules that individuals must follow for the good of the society as a whole, or rules that's supposed to be the good of the society as a whole. Some laws are and have been relatively uncontroversial. For example, law that mandates driving on the right side of the road has not been a subject of debate, a source of emotional soul-searching, or a stimulus to civil disobedience. Meanwhile, in the context pertaining to abortion, capital punishment, euthanasia, affirmative action, busing, and other more. Exactly how laws regulating matters like this should be written and interpreted are issues of heated controversy. So too is the role of testing and assessment in such matters. To the extent that the Code of Professional Ethics is recognized and accepted by members of a profession, it defines the standard of care expected of members of that profession. In this context, we may define standard of care as the level at which the average, reasonable, and prudent professional would provide diagnostic or therapeutic services under the same or similar conditions. Members of the public and members of the profession have not always been on the same side of the fence with respect to issues of ethics and law. And let's review how and why this has been the case. So for the case, the concerns of the public, misunderstanding of testing, the assessment enterprise has never been well understood by the public. And even today, we might hear criticisms based on a misunderstanding of testing. So for the possible consequences of public misunderstanding include fear, anger, legislation, litigation, and administrative regulation. People or the public believe that so people or the public believe or thought that undergoing testing and the results from this testing might be used against them. That's why they are fearful of testing. So for the Common Core State Standards, a state-led effort to bring greater interstate uniformity what constituted proficiency in various academic subjects. However, Common Core has probably been more at the core of public controversy than anything else. Efforts to dismantle these standards have taken the form of everything from verbal attacks by politicians to local demonstrations by consortiums of teachers, parents, and students, which will be further discussed in Chapter 10 and will not be included in my report. For the World War I, concern about the use of psychological tests first became widespread in the aftermath of it, when various professionals as well as non-professionals sought to adopt group tests developed by the military for civilian use in schools and industry. Growing public discomfort with the burgeoning assessment industry were popular magazine articles featuring stories with the titles such as abuse of tests. During World War II, the nationwide military testing in the 1940s did not attract as much popular attention as the testing undertaken during World War I. Sputnik, which is the satellite launched by USSR or Soviet Union, which took the attention of the momentous effect on testing in the United States. This unanticipated action on the part of a Cold War enemy immediately compounded homeland security concerns in the United States. The prospect of a Russian satellite orbiting Earth 24 hours a day was most unsettling as it magnified feelings of vulnerability. On a positive note, the Soviet launch of Sputnik had the effect of galvanizing public and legislative opinion around the value of education in areas such as math, science, engineering, and physics. More resources would have to be allocated toward identifying the gifted children who would one day equip the United States to successfully compete with the Soviets. After a year of launching Sputnik, Congress passed the National Defense Education Act, which provided federal money to local schools for the purpose of testing ability and aptitude to identify gifted and academically talented students. This event triggered the proliferation of large-scale testing programs in schools. At the same time, the use of ability tests and personality tests for personal selection increased in government, the military, and business. The wide and growing use of tests led to renewed public concern, reflected in magazine articles such as Can everyone be pigeonholed? What the test do not test. So for the 1969, the fires of public concern about testing were again fanned when widespread media attention was given to the publication of an article in the prestigious Harvard Educational Review entitled How Much Can We Boost IQ and Scholastic Achievement? Its author, Arthur Jensen, argued that genetic factors are strongly implicated in the average Negro-white intelligence difference. What followed was an outpouring of public and professional attention to nature versus nurture issues, in addition to widespread skepticism about what intelligence tests were really measuring. By 1972, the U.S. Select Committee on Equal Education Opportunity was preparing for hearings on that matter. However, according to Haney, 1981, the hearings were cancelled because they promised to be too controversial. The extent of public concern about psychological assessment is reflected in the extensive involvement of the government in many aspects of the assessment process in recent decades. Assessment has been affected in numerous and important ways by activities of the legislative, executive, and judicial branches of the federal and state governments. A sampling of some landmark legislation and litigation is presented in Table 2-1. So these are the legislation and litigation. The Americans with Disabilities Act of 1990, the Civil Rights Act of 1964, amended in 1991, and other more. So legislation is an act of making and enacting laws by an official organ of the state. Although the legislation summarized in Table 2-1 was enacted at the federal level, states also have passed legislation that affects the assessment enterprise. In the 1970s, numerous states enacted minimum competency testing programs, formal testing programs designed to be used in decisions regarding various aspects of students' education. The data from such programs was used in decision-making about grade promotions, awarding of diplomas, and the identification of areas for remedial instruction. These laws grew out of grassroots support for the idea that high school graduates should have, at the very least, minimal competencies in areas such as reading, writing, and arithmetic. Truth in testing legislation. The primary objective was to give the takers a way to learn the criteria which they are being judged. Passed at the state level beginning in the 1980s. To meet that objective, some laws mandate the disclosure of answers to post-secondary and professional school admissions tests within 30 days of publication of test scores. Some truth and testing laws require providing descriptions of the test's purpose and its subject matter. Number 2, the knowledge and skills the test purports to measure. Number 3, procedures for ensuring accuracy in scoring. Number 4, procedures for notifying test takers of errors in scoring. And number 5, procedures for ensuring the test takers' confidentiality. Some laws mandate the involvement of the executive branch of government in their application. Title 7 of the Civil Rights Act of 1964 created the Equal Employment Opportunity Commission, or EEOC, to enforce the act. The EEOC has published sets of guidelines concerning standards to be met in constructing and using employment tests. In 1978, the EEOC, the Civil Service Commission, the Department of Labor, the Justice Department jointly published the Uniform Guidelines on Employee Selection Procedures. Here is a sample guideline. The use of any test which adversely affects hiring, promotion, transfer, or any other employment or membership opportunity of classes protected by Title VII constitutes discrimination unless the test has been validated and evidences a high degree of utility as hereinafter described, and the person giving or acting upon the results of the particular test can demonstrate that alternative suitable hiring, transfer, or promotion procedures are unavailable for use. Note that here the definition of discrimination as exclusionary coexists with the proviso that a valid test evidencing a high degree of utility, among other criteria, will not be considered discriminatory. Generally, however, the public has been quick to label a test as unfair and discriminatory regardless of its utility. As a consequence, a great public demand for proportionality by group membership in hiring and college admissions now coexists with a great lack of proportionality in skills across groups. So, in the employment selection procedures, there will be the quota system, the disparate treatment, employment discrimination, reverse discrimination, and disparate act. So quota system, a selection procedure whereby a fixed number or percentage of applicants from certain backgrounds were selected. Employment discrimination, the practice of making distinctions in hiring, promotion, or other selection decisions that tend to systematically favor members of a majority group, regardless of actual qualification for positions. Reverse discrimination, the practice of making distinctions in hiring, promotion, or other selection decisions that systematically tend to favor members of a minority group, regardless of actual qualifications for positions. Disparate treatment refers to the consequence of an employer's hiring or promotion practice that was intentionally devised to yield some discriminatory result or outcome. And disparate impact refers to the consequence of an employer's hiring or promotion practice that unintentionally resulted in a discriminated result or outcome. For the litigation is the court-mediated resolution of legal matters of a civil, criminal, or administrative nature, sometimes been referred to as judge-made law. So, PARC against Commonwealth of Pennsylvania, 1971. In the PARC case, the Pennsylvania Association for Retarded Children brought suit because children with intellectual disability in that state had been denied access to public education. Mills against Board of Education of District of Columbia, 1972. In Mills, a similar lawsuit was filed on behalf of children with behavioral, emotional, and learning impairments. And lastly, Dubert against Merrill Doe Pharmaceuticals, a landmark case heard by the U.S. Supreme Court in June 1993, has implication for the admissibility of expert testimony in court. So for summary, laws are mandated to be followed by the people for the good of the society as a whole. However, there are uncontroversial and uncontroversial laws. Members of the public and members of the profession have not always been on the same side of the fence. Even now, there is still a big misunderstanding on the assessment enterprise, which there is a need for education on this field. Legislation is the act of making and enacting laws by an official organ of the state. And lastly, litigation is the court-mediated resolution of legal matters of a civil, criminal, or administrative nature, also known as judge-made law.